The Supreme Court issued a 5-4 order, which completely shook up our country and created a significant battle between the state of Texas and the Biden administration over the border. This issue is now back in front of the Fifth Circuit for a final decision. So let's talk about what is happening. Now, before we jump into this video, I want to mention that today is my birthday. As of filming this, today is my birthday. So I just wanted to say thank you guys so much for all of your support. Thank you for everything you do for me and the channel. And again, if you guys would like to support the channel, just simply consider subscribing. That is a free gift that you can give me on my birthday, or just comment down below happy birthday. That does help the channel to grow and helps these videos get out to more people. As I mentioned in the intro, in this video, we need to talk about a 5-4 order, which was recently issued by the Supreme Court, and it involves the Texas border and the dispute about whether or not the federal government can actually cut concertina wire, C-wire in certain areas of Texas, and essentially the right of Texas to defend itself against what they believe is an invasion. Now, the Biden administration is trying to take the opportunity that was opened up after the Supreme Court order, and they're trying to get this entire case thrown out by the lower court, and also at the same time, they're asking for the Fifth Circuit to rule in their favor and allow federal agents to enter certain areas in Texas and to also cut C-wire along those certain areas. The case we will be discussing in this video is the Department of Homeland Security versus the state of Texas. The recent Supreme Court order involves overruling a temporary preliminary injunction that was granted by the Fifth Circuit Court of Appeals, and that was a 3-judge panel, a motions panel. The Fifth Circuit motion panel's decision prevented the United States Border Patrol from cutting, destroying, or otherwise interfering with C-wire that the state of Texas had put up along 29 miles of municipal and private land in the Eagle Pass area. In this case, Texas originally sued the federal government in a Texas federal district court, and they alleged trespass in violations of the Administrative Procedures Act, also known as the APA. Originally, in the lower court case, Texas obtained a temporary restraining order, or a TRO, which barred the federal government from interfering with the state of Texas and their C-wire in certain areas, and the only exception to that was when there would be medical emergencies. Texas then later sought a more permanent preliminary injunction that was pretty much for the same purposes. However, that preliminary injunction was denied. What was interesting about the lower court's denial was the fact that the judge agreed with Texas on multiple issues, including the fact that the government there, the federal government cutting the wire, was generally not necessary to prevent medical emergencies. The court rejected the notion that medical emergencies would then justify the destruction of the fence in these areas, and that the cutting the wire for one emergency does not then allow the federal government to justify cutting it and leaving it open for multiple days so that thousands of individuals could go through that area. Texas then quickly appealed that up to the Fifth Circuit. They sought an appeal of the denial of that preliminary injunction, and then at the same time, Texas sought an emergency temporary administrative stay, so they wanted temporary administrative relief from the Fifth Circuit. And the Fifth Circuit motions panel ultimately did grant the administrative relief. In response to the granting of that administrative relief, then the federal government, the Biden administration, decided to go to the Supreme Court on an emergency basis. They wanted the Supreme Court to remove that administrative relief because that type of relief that was issued by the motions panel in the Fifth Circuit was essentially blocking the federal government there, the Biden administration, from entering the areas there and cutting the wire. They asked the Supreme Court to step in early and to vacate what the Fifth Circuit said for the administrative relief. And on review, the Supreme Court issued a 5-4 order, which granted the federal government's request to vacate that administrative relief. The emergency order of the Supreme Court stated that application to vacate injunction presented to Justice Alito and by him referred to the court is granted. The order of the United States Court of Appeals for the Fifth Circuit is vacated. Justice Thomas, Alito, Gorsuch, Kavanaugh would deny the application to vacate the injunction. So that means that ultimately the Supreme Court voted in favor of removing the administrative relief that was issued by the Fifth Circuit. Essentially, in a backdoor way, the Supreme Court removed the block on the Border Patrol, which was essentially preventing them from cutting wire in that area. And the two judges who jumped the line to rule in favor of the Biden administration was Justice Barrett and then also Chief Justice Roberts. Now, in reaction to that Supreme Court order, this case then went back down to the Fifth Circuit, but also the governor there, Governor Abbott in Texas, issued a letter to the Biden administration stating that the federal government and the Biden administration have failed to enforce federal laws that would protect the state of Texas and their residents. Therefore, under Article 1, Section 10, Clause 3, the state of Texas has a right of self-defense, which they are going to engage in. So the state of Texas is saying this is a right of self-defense issue, and therefore they're going to take appropriate steps to defend their state from an invasion and to also protect their residents. Now, after that Supreme Court 5-4 order, the Fifth Circuit Court of Appeals responded by first sending this case back down to the lower court for 60 days to develop more evidence and facts around this issue. That time has now run, and the Fifth Circuit has recently heard arguments on this case. Recently, the Fifth Circuit held oral arguments on this case to determine if they're going to overrule what the lower court said, and ultimately if they're going to side with the state of Texas. One of the interesting things that also developed is during that more limited 60-day remand to the lower court, the Biden administration took that limited remand time as an opportunity to then file a motion to dismiss the entire case. In that motion to dismiss, the Biden administration argued that the court correctly denied Texas' motion for a preliminary injunction because the state is not likely to succeed on its claims. Consistent with that ruling, the court should now dismiss this case for a lack of jurisdiction and failure to state a claim. Texas responded to that attempt by arguing that the Biden administration is simply trying to dismiss this case at a stage that was improper. This was a remand for a limited time period for a development of more evidence and facts, and that what the Biden administration is doing is improper. That motion to dismiss is still pending in front of the lower court. However, like I mentioned, the Fifth Circuit has now taken control of this case once again, and they heard arguments on this issue. The hearing took place in front of the Fifth Circuit, and interestingly, the Biden administration argued to the Fifth Circuit that the Fifth Circuit does not have the power to consider any of the new evidence and facts that were developed at the lower court level, that they just sent the case back down to develop, that the Fifth Circuit there should not even have done that, and that they should not review any new information. During this hearing, multiple judges on the Fifth Circuit panel brought this up to the government's attorney, to the federal government, and you could tell that the judges did not like this argument and that it really did actually make them mad. The Fifth Circuit judges pointed out that the federal government has told them expressly here that they are not allowed to rely on any of the new information or any new facts that have happened essentially since the lower court has issued their original decision. So the federal government here is arguing that any new information, any new evidence that has been developed after the date of the original decision here back in 2023, that none of that new information can be considered. But here is the very interesting rub. At the same time, the Biden administration here is saying that they can use new information, they can use new facts, and if they decide to go to the Supreme Court once again, they can use those new evidence and those new facts if they want. So it's very interesting because they're saying we are different, we can use whatever new facts and information that we want, but you, Fifth Circuit, you are locked in and you cannot consider anything new. The judges asked what happens if the federal government here does not like the Fifth Circuit's new decision. Are they simply going to go to the Supreme Court again and bring up new facts once again? But here the Fifth Circuit can't, rely on any new facts, new information, and essentially preemptively stop this merry-go-round from going back and forth to the Supreme Court. And ultimately, the Biden administration argues that, yes, that's correct, that the Fifth Circuit can't use any new information, and that if they want here, the Biden administration can simply go back to the Supreme Court and use new facts and evidence. And again, I don't think that the Fifth Circuit liked that at all. The Biden administration also argued that the Supreme Court's prior vacatur in this case should actually dictate the outcome of the Fifth Circuit's review here, that essentially they are locked in based on what the Supreme Court said in the vacatur, which was very interesting, and I don't think that the Fifth Circuit liked that either. Now, I think from listening to the arguments in the Fifth Circuit, it seems like the court will side with the state of Texas and likely reverse what the district court said in their decision and grant Texas their request for a preliminary injunction. The tone of the Fifth Circuit seemed to be that they did not like what the Biden administration was bringing forward, and they don't like that the Supreme Court reversed their prior ruling and that the Biden administration here was trying to circumvent what they said. So arguments have now been submitted to the Fifth Circuit, and we're now waiting for their decision. This is going to be something very interesting to watch going forward, because again, this will dictate maybe how the Biden administration will be able to enter certain areas, during this transitional period from the Biden administration to the Trump administration. We'll see how this develops, but again, very interesting. So those who are interested about the Texas Eagle Pass lawsuits, the C-Wire lawsuit, that's where it currently stands after the Supreme Court's recent 5-4 order. So hopefully you found this video helpful. Again, thank you guys so much for all of your support and watching this channel. If you guys like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.